हमारे पोस्ट इंडिपेंडेंस के हीरो थे, जो हमारे इंडिपेंडेंस के जमाने में मूवमेंट में जुड़े हुए थे, वो तमाम ऐसे लोग, एक लंबी श्रृंखला है, मैं सबका नाम नहीं लेना चाहता हूँ। तो उसके बाद उन लोगों ने एक कमेटी बनाई, और उस कमेटी को बनाने के बाद जिसमें सभी स्टेक होल्डर्स को, लॉ कमीशन को भी, हाई कोर्ट को भी, सुप्रीम कोर्ट को भी, बार काउंसिल ऑफ इंडिया को, सब स्टेक होल्डर के साथ कंसल्टेशन किया गया, और सारे लोगों के कंसल्टेशन के बाद एक कंप्रहेंसिव टाइप का एक्ट उन्होंने एडवोकेट एक्ट 1961 में बनाने का तय किया। तो अब जब एडवोकेट एक्ट 1961 बन गया, आज जिस हम इस लीगल प्रैक्टिशनर एक्ट 1879 को, इसको ऑब्सोलीट कर रहे हैं। केवल इसका जो एक सेक्शन था, लिस्ट ऑफ टाउट्स, तो आई थिंक सो उसी को ऑब्सोलीट नहीं किया कि हम अभी भी देश की आज़ादी के बाद लिस्ट ऑफ टाउट्स के खिलाफ कोई हम एक्ट न बनाएं, कोई कानूनी प्रावधान न दें। अभी भी गांव का गरीब आदमी अगर अपने कानून पाने के लिए आए और वो बीच में उस कचहरियों में, कोर्ट में, अगर उन टाउट से, दलालों के चंगुल में फंस जाए, और जिस तरीके से आप देखते हैं आज कि आप स्टेशन पे उतरते हैं या कहीं बस स्टेशन पे या कहीं कोई मरीज आता है, तो किस तरह से आज उस फील्ड में भी वो टाउट लगे रहते हैं कि नहीं, आप इस हॉस्पिटल में चलिए, आप इस डॉक्टर के पास चलिए। तो मुझे लगता है कि अगर इस तरह के न्याय, जो सबसे बड़ी न्याय प्रक्रिया, न्याय मिलना चाहिए, न्याय केवल मिलना चाहिए नहीं, बल्कि ये प्रतीत भी होना चाहिए कि लोगों को न्याय मिल रहा है। तो इसलिए जो प्रधानमंत्री जी ने देश में एक स्वच्छता अभियान शुरू किया, तो आज वो स्वच्छता अभियान अगर न्यायिक प्रक्रिया में शुरू हो रहा है, तो मैं तो अपील करूंगा कि पूरे सदन को सर्वसम्मत से इसको पास करना चाहिए और इसका स्वागत करना चाहिए। क्योंकि आप देखिए कि इसके पहले भी हमने रिव्यू किया है, जो हम जन विश्वास बिल लेके आए थे, उस जन विश्वास बिल में भी, जिसमें 183 प्रोविजन थे, उस 183 प्रोविजन में अक्रॉस 42 एक्ट्स ऑफ 19 मिनिस्ट्री, तो देश ने तो शायद एक इतिहास बनाने का काम किया है। और आप सौभाग्यशाली, आप साक्षी हैं, हम कहीं बैठे हो कि आप उसके साक्षी हैं कि उस कॉलोनियल लिगेसी के जो 19 मंत्रालयों के 42 एक्ट ऐसे थे जिसमें केवल ब्रिटिशर्स की, मतलब उस दास्ता को परिलक्षित करता था, और उन्होंने अपने इंटरेस्ट में बनाया था। पहली बार नरेंद्र मोदी जी की सरकार ने उन सारे 19 मिनिस्ट्रीज के 42 एक्ट के 183 प्रोविजन को ऑब्सोलीट करके देश को एक स्वच्छता देने का काम किया है। तो मुझे लगता है कि ये बात तो उसी दिशा में और आगे पहल की गई। और ये जो आज इस बिल को लाए हैं, इस बिल के लाने से निश्चित तौर से एक फायदा ये भी होगा कि ये दिस एक्ट, या दिस इज नॉट ए सिंगुलर लेजिस्लेशन, दिस इज ए पीस ऑफ कंप्रहेंसिव मिशन ऑफ द गवर्नमेंट टू रिमूव ऑल ऑब्सोलीट लॉज इन द कंट्री। तो ये तो क्लैरिटी है, मानिए क्लैरिटी क्या है कि हम इस देश में जो भी हमारे एक्ट में है चीजों का, गवर्नमेंट कमिटेड है, सरकार प्रतिबद्ध है कि हम जो भी ऑब्सोलीट लॉ हैं उनको हम ऑब्सोलीट करेंगे, जो इस तरीके की चीजें हैं। आज मैं कहता हूं कि ये आज का जो अमेंडमेंट बिल है, ये अगर कोर्ट में उस न्यायिक प्रक्रिया में शुचिता और पवित्रता का काम करेगा, या जिस तरीके से रिमूवल ऑफ टाउट्स फ्रॉम कोर्ट प्रीमाइसेस करेगा, और इसका अधिकार किसको होगा? सरकार को नहीं होगा। उस प्रीमाइसेस में टाउट्स को आइडेंटिफाई करने के लिए, उस टाउट्स के खिलाफ कोई कार्रवाई करने के लिए कौन इसमें करेंगे? इसको करने के लिए जो मिशन है, जो पावर दिया गया है, वो सुप्रीम कोर्ट के जज को है, हाई कोर्ट के जज को है। ये साफ है कि की फीचर्स ऑफ द बिल इंक्लूड कि टाउट्स के लिए द बिल प्रोवाइड दैट एवरी हाई कोर्ट, डिस्ट्रिक्ट जज, सेशन जज, डिस्ट्रिक्ट मैजिस्ट्रेट एंड रेवेन्यू ऑफिसर नॉट बिलो द रैंक ऑफ डिस्ट्रिक्ट कलेक्टर। मतलब ये नहीं कि कोई ऐसे आईएएस जूनियर हो, वो आईएएस जो डिस्ट्रिक्ट मैजिस्ट्रेट होगा, मुझे रिस्पॉन्सिबल फॉर द लुकिंग आफ्टर ऑल द रेवेन्यू केसेज एंड रेवेन्यू अफेयर, ही विल बी ओनली दिस पावर, ही कैन एक्सरसाइज दिस पावर, या तो हाई कोर्ट का जज, डिस्ट्रिक्ट जज, सेशन जज। और जिस तरीके से ये अधिकार तो उन्हीं न्यायिक प्रक्रिया से जुड़े हुए, कोसी जुडिशियरी से जुड़े हुए लोगों को दिया गया है। ये कोई एग्जीक्यूटिव पावर नहीं है, ये कोई सरकार के या प्रशासन के हाथ में नहीं आ रहा है कि जो हम किसी को टाउट बना देंगे या किसी के खिलाफ आइडेंटिफाई करके हम उसको पेनलाइज कर देंगे। पनिशमेंट कर देंगे। ये हमने सीधे सीधे ये अधिकार हाई कोर्ट के जजेस को दिया है, हमने डिस्ट्रिक्ट कोर्ट के जजेस को दिया है, सेशन जज को दिया है, और रेवेन्यू में जो रेवेन्यू में मुकदमे देखते हैं उनको दिया गया है। आप देख लीजिए। और मैं समझता हूं कि टाउट रेफर्स टू ए पर्सन हु procures the employment of legal practitioner in a legal business in return of any payment, तो ये तो साफ है। And frequent places such as the premises of civil or criminal courts, revenue offices or railway stations to procure such employment। इस तरीके जो घूम करके गरीब लोगों का या अपने उन मौकिल का या जो न्याय पाने के लिए हैं उनको जिस तरीके से ले करके उनका एक्सप्लॉइटेशन है, तो मुझे लगता है कि ये तो ऐतिहासिक कदम है। ये कानून केवल एक जगह नहीं, कन्याकुमारी से कश्मीर के सुप्रीम कोर्ट, हाई कोर्ट से लेकर के डिस्ट्रिक्ट और नीचे के कोर्ट में जिस तरह से न्यायिक प्रक्रिया में इस कानून के अमेंडमेंट होने के बाद जो न्यायिक प्रक्रिया के लिए स्वच्छता आएगा, ये देश के लिए एक ऐतिहासिक वरदान साबित होगा। इसलिए मैं कहना चाहता हूँ कि द कोर्ट और जज में एक्सक्लूड फ्रॉम द प्रीमाइसेज ऑफ द कोर्ट एनी पर्सन हुज नेम इज इंक्लूड इन द लिस्ट ऑफ द टाउट। एंड प्रिपरेशन ऑफ द लिस्ट देखिए क्या है। Preparation of the list, the authorities empowered to frame and publish the list of touts may order subordinate courts to hold an inquiry into the conduct of persons। ऐसा नहीं कि किसी इनोसेंट आदमी को या किसी साधारण आदमी को भी इस तरीके से कर दिया जाएगा। तो उनको एक पूरा प्रॉपर इंक्वायरी होगी, कोर्ट्स टू होल्ड एन इंक्वायरी इनटू द कंडक्ट, उसके कंडक्ट के बारे में, ऑफ पर्सन्स एलिज्ड आर सस्पेक्टेड टू बी टाउट्स, मतलब जिसके बारे में ये होगा कि ये कोर्ट में लगातार है और ये टाउट्स की भूमिका निभा रहा है, लोगों को एक्सप्लॉइट कर रहा है, लोग दलाली काम कर रहा है, तो ऐसे लोगों को उनके कंडक्ट की इंक्वायरी होगी, उनके सस्पेक्ट में, तब उसके खिलाफ उनकी कार्रवाई होगी। वंस सच ए पर्सन इज प्रूवन टू बी ए टाउट, his name may be included by the authority in the list of the touts। No person will be included in such list without getting an opportunity or showing cause actions his inclusion। तो ऐसा भी नहीं कि किसी का नाम डाला जा सकता है। पेनाल्टी साफ है कि any person who acts as a tout while his name is included in the list of touts will be punished with imprisonment up to the 3 months and a fine up to ₹500 or both। तो इस तरह से मानवर कम से कम पहली बार जो आज हम उस एक्ट को एब्सोल्यूट कर रहे हैं, उस एक्ट के एब्सोल्यूट करने के बाद जिस तरीके से है, पहले के कैसे वकील थे आपको याद होगा। मैं वेस्ट बंगाल की बात करता हूँ, कल्याण जी बात करें, महर्षि अरविंद का केस हुआ था, खुद सीआर दास जी ने खुद अपनी सर्विसेज उनको दिया था। हमारे अधिवक्ताओं की इतिहास को देखा जाए तो शायद स्वर्ण अक्षरों में है कि ये नहीं है कि कोई किसी को के पास ले जाने की जरूरत है। महर्षि अरविंद के खिलाफ केस हुआ, उसमें वो नहीं थे, तो इसके बावजूद सीआर दास जैसे एडवोकेट ने उनको जिस तरीके से अपनी सेवाएं दिया और उनके लिए किया। तो आज हमारे अधिवक्ताओं का इतिहास एक अपने आप में बहुत बड़ा है और इससे एक कम्प्रहेंसिव फ्रेमवर्क बनेगा जिसमें एडवोकेट्स एक्ट 1961 जो अपने इस एक्ट से रेगुलेट करेगा, गवर्न करेगा, पूरे देश के जो प्रैक्टिस ऑफ लॉ है इन दिस कंट्री उसको करेगा। और केवल ये बिल जो पेनलाइजिंग है वो केवल द प्रैक्टिस ऑफ टाउटिंग अंडर द एडवोकेट्स एक्ट, कि एडवोकेट्स एक्ट के नाम के अंतर्गत अगर वो कोई टाउट करते हैं या इस तरीके काम करते हैं, ये केवल उन्हीं के लिए है। और जिस तरीके से आप देखिए कि इस बिल को कितनी चर्चा करके लाया गया। दिस लेजिस्लेशन वाज आल्सो रिकमेंडेड बाय द लॉ कमीशन ऑफ इंडिया। तो जब लॉ कमीशन ऑफ इंडिया ने अपनी 249वीं रिपोर्ट में देखा जाए तो इन इट्स रिपोर्ट 249 टाइटल ऑब्सोलीट लॉज एंड वारंटिंग इमीडिएट रिपील। तो इस तरह से ये ऑलरेडी लॉ कमीशन ऑफ इंडिया ने अपनी रिपोर्ट 249 में भी एक तरह से रिकमेंड किया है सरकार के लिए कि इसको किया जाए, ऑब्सोलीट किया जाए और इसमें इमीडिएट रिपील करने की एक मतलब अपेक्षा की गई है। उसी को सरकार उसके अनुरूप लेके आ रही है। और जिस तरीके से इस कानून को लाने के पहले इस सरकार ने इस बिल पे सभी जो वेरियस स्टेक होल्डर्स हैं उनके साथ, चाहे जो लीगल प्रोफेशन में लगे, आखिर इंडिया का सबसे लीगल प्रोफेशन कौन है? लॉयर्स हैं, एडवोकेट्स हैं और बार काउंसिल ऑफ इंडिया उनका सबसे बड़ा ऑर्गेनाइजेशन है। तो बार काउंसिल ऑफ इंडिया के साथ मतलब ये नहीं है कि कोई अपने आप सरकार ने इस कानून को लाने की बात की। जो सीधे जुड़े हुए हैं देश भर की न्यायिक प्रक्रिया में, जो अधिवक्ताओं के हितों की रक्षा करने वाले अधिवक्ता हैं, जो न्याय देने की, न्याय की प्रक्रिया या उसको व्याख्या करने वाले उन कोर्ट्स में हमारे अधिवक्ता हैं, उनके उस सबसे बड़े बार काउंसिल ऑफ इंडिया के साथ भी हमारी सरकार ने एक कंप्रहेंसिव बिल बनाने के लिए उनसे कंसल्ट किया। और उसके बाद इस कंसल्टेशन के बाद जो एक इसमें शामिल करने की बात आई कि टाउटिंग इन द लीगल प्रोफेशन इज अगेंस्ट द स्पिरिट ऑफ द प्रोफेशन, मतलब स्वयं अधिवक्ताओं ने माना है कि ये न्याय में हमारे है, इस न्याय के जो स्पिरिट है, जो भावना है, जो हमारे प्रोफेशन की भावना है कि हम क्या किसी एग्रीव्ड को न्याय दिला सके। अधिवक्ता क्या करता है कि अगर कोई एग्रीव्ड है या कोई थोड़ा मैं जल्दी कंक्लूड कर दूंगा, तो इस तरीके से है। तो मैं आपसे कहना चाहूँगा कि खुद ही हमारे माननीय मंत्री जी ने कहा कि हम इसमें केवल जो 1961 का हमारा अमेंडमेंट है एडवोकेट्स एक्ट में, उस 161 के एक्ट में हम केवल सेक्शन 36 को जोड़ने का काम कर रहे हैं। और वो 36 इसलिए इंक्लूड कर रहे हैं इसमें कि सेक्शन 30 जो लिस्ट ऑफ द टाउट्स है, उसको हम पेनलाइज करने के लिए या न्यायिक प्रक्रिया की स्वच्छता के लिए इसमें जोड़ना है। और ये बिल जो रिपील कर रहा है, कुछ सर्टेन सेक्शंस है जो पूरे बिल को तो हम उस समय के उसको रिपील कर रहे हैं। केवल इसमें जो सर्टेन सेक्शंस रिलेटेड टू टाउट्स अंडर द लीगल प्रैक्टिशनर एक्ट 1879 का है, जिसको कि हम आज हमारे माननीय मंत्री जी लेके आ रहे हैं उसको एक तरह से अपसीट करने की, लेकिन उसके एक सेक्शन को, सेक्शन 36 को इसमें जोड़ने के लिए किया है। तो नाउ द 1961 एक्ट कंसोलिडेट्स the law related to legal practitioner and constitutes bar council and the all India bar council। तो इस तरह से मुझे लगता है कि आज ये सदन के लिए एक ऐतिहासिक दिन है। जब पूरा देश इस बात के लिए साक्षी बनेगा, गवाह बनेगा कि पूरे देश में जिस तरह से न्यायिक प्रक्रिया में छोटे कोर्ट से लेके तहसील के से लेके मुंसिपल मजिस्ट्रेट के कोर्ट से लेके सेशन जज के कोर्ट से लेके डिस्ट्रिक्ट जज के कोर्ट से हाई कोर्ट, सुप्रीम कोर्ट तक सभी कोर्ट्स में एक न्यायिक प्रक्रिया को बिना किसी टाउट के, बिना किसी बिचौलिए के, बिना किसी इंटरमीडिएटरी के अगर किया जाए, ठीक है, धन्यवाद, तो बिना किसी इंटरमीडिएटरी किया जाए, तो मुझे लगता है, मैं अपील करूंगा कि सत्ता पक्ष के हों, प्रतिपक्ष के हों, इस बिल को सर्वसम्मत से पारित करें। धन्यवाद। जय हिंद।
श्री ए राजा।
Sir, thank you very much for the opportunity that has been offered to me to speak on this small amendment. Sir, when this Parliament discussed the 42nd Amendment, the biggest controversial amendment, it was said that the legislative competence of the Parliament cannot be questioned in the court of law. That triggered the controversy. Ultimately, it was settled down later by the virtue of 44 Amendment. The legislative capacity of the Parliament cannot be questioned in those days. That was nailed down. Now, the capacity of Parliament's capacity of legislation became a mockery through this bill. Sir, I do not know how this bill was drafted without giving any due care for the legislative competency of this Parliament. Sir, ever since this government, BJP government, came into power, the Parliament is being misused. Most of the state subjects were brought to here for enactment of laws encroaching the state power. Ultimately, state autonomy became laughing stock. Cooperative federalism becomes the laughing stock. Sir, it is a small bill, but I am not able to understand the way in which the nationalism was put up everywhere, even in the Advocates Act. The Honorable Minister says colonial law. Yes, colonial law. 1879, the provision is there. You want to repeal it. But by way of repealing, you are introducing the same section, importing the same section in the new law. What does it mean? Is it not anti-colonial or colonial law? I am not able to understand the rationality behind the government to bring this law. Again, sir, the simple reading. How a person can be listed as a tout. Explanation. I quote, the passing of a resolution declaring any person to be or not to be a tout by majority of the members present at the meeting. Who are all the members in the committee? Nothing mentioned. Who are all the members? Then, by evidence of general repute, by evidence of the general repute, evidence must be tendered by a person who is having reputation in the society. All right. The next sentence is very dangerous. Or otherwise. What happened in Article 356? On the recommendation of the governor, a state government can be dismissed on recommendation of the governor or otherwise. That otherwise was used by the president when the Tamil Nadu government was dismissed without government recommendation. Such a dangerous provision for small advocate acts, you are putting same otherwise here. How it is going to be used or misused, nobody can say. Then, come for the meaning for tout. Who procures, in consideration of any remuneration, moving from any legal practitioner. What does it mean? Money will go from the pocket of the advocate to the tout. See, this house many times discussed at length about the corruption. The Prevention of Corruption Act says, periodically it has been amended, that not only the receiver, the giver of the corrupt money also culprit under this act. He has to be convicted. The tout is going to be eliminated and given imprisonment or penalty. Does it not mean to say the person who is giving money also liable for the offense? What type of justice you are rendering to the A and B between the money is exchanged? So the very purpose of the corruption, Prevention of Corruption Act itself is defeated here by way of the way in which the bill is drafted. Sir, next one. The first time I have come across a bill that has been submitted to the parliament, may be correct or may not be correct, I may be correct or may not be correct, that objects and reasons were not at all given in the bill. For what purpose we are going to introduce, give this amendment? Whether the Bar Council of States, whether the Bar Council of India is going to be consulted when a person is listed as tout or not. What will be the role of the Bar Council? Chief Justice of India, a decade ago, Justice Barucha said in the open meeting on the eve of his retirement that the 20% of the judiciary become corrupt. He made an open statement. The problem for the litigant is, a man is having case in a particular court, whether that judge comes under 20% or 80%, how does he demark it? So, you remember the entire judicial system, right from doubts to up to judges. But you small matter, you are not able to draft a clear law to serve the purpose. So what type of purpose is going to be served? Nothing. Sir, ignorance of law is not an excuse. That is a legal maxim. A person cannot claim, I did not know the law. But what about the society? The society, still 30% of the people are illiterate, so far as law is concerned. Again, so far as law is concerned, more than 70% of living persons are unaware about the legal system. So in such a situation, yes, you want to regularize the system of doubts, frame some guidelines, reasonable guidelines, but permit or either not permit. A healthy discussion must be there. All forums, including the Bar Council of India. Sir, suppose a junior advocate, not a junior advocate, advocate on record. You are designing advocate on record. After the examination done by the Bar Council of India or Supreme Court judges, a man has been designated AOR, advocates on record. A senior advocate designated by High Court and Supreme Court cannot be advocate on record. No, I'm not. See, AOR is separate. Senior advocate is separate. Who is approaching senior advocate? Litigant? No. AOR. The role of the AOR, advocate on record, becomes almost similarity with the doubt as far as the senior advocate is concerned. So, a judicial system needs some middleman to bypass every pole in the judicial system. Whether it must be eliminated or that may be regularized with the rational application. That is the question before this House. I think that this bill is having no meaning at all because you are completely just mechanically transport a section which is available in 1879 Act to the new Act without application of mind. My only question is, what type of exercise that has been done by the government? Or what type of inference that has been drawn out of this 100 years old law? Whether this provision is essential, if the potentials, the provision is workable or not, practicality of the provisions has been appraised or not. Nothing has been done by this government, but everything you want to say, you want to remove the corruption in the name of Narendra Modi, starting from small bill up to big bill. So, my only thing is, don't make this parliament a laughing stock. Don't do the meaningless exercise for which the competency of this parliament is undermined. So, revisit the law, take back this law, draft carefully, try to revisit, try to regularize, or try to make a system which is workable in the judicial system. Thank you, sir.
Very good.
Shri Kalyan Banerjee.
Thank you, sir. I will bring the attention of the, I wish to bring the attention of the Honorable Law Minister to you. First question is, really, every categories of touts in the field of the law have been brought within the ambit of this statute? Is it correct? Tout is there in everywhere, lower judiciary up to Supreme Court. But these types of bill, practically you are identifying few persons who are in the subordinate court or the district court. What is the real intention to identify the tout? I understand this bill is what Mr. Raja has said just now, the replacement of the old provisions of the legal practitioners. Nothing more than that. You are taking that colonial. I have no difficulties. But when you are making an attempt to bring this bill, you think broad. There are a number of touts. Sir, I tell you one thing. It is very easy to identify tout who are poor. How much touts are there in the judiciary who are extremely sophisticated? Can you identify? The process you have started, I understand, appreciate. But the reality is this: tout is everywhere. Tout is sophisticated. Tout is there. Tout is here going to 5-star hotels. Tout is there going to 7-star hotel. Tout is taking you in different places of the country. You can't identify that tout because they are sophisticated. They are coming from very big universities. They are having Mercedes. You can't identify that touts. You can't identify. That's exactly I am telling that you are not, this is not a broad, you are not bringing all types of touts. Today when the discussion is there, let the discussion. I know it will not be done now. Think in future about this. No doubt about it. Let me explain myself. What is this tout, Sylvia? You know, sir, what we know about this? We are laws. What are the laws? Statute law. Correct? There is a law, case law. This is the laws are known to everyone. Statute law and case law applicable in the court. All we proceed. There is another law which is called face law. And face law is the important for having an order from the higher judiciary, highest judiciary. That's the practical thing. And for the face law, litigants have to spend lakhs and lakhs rupees. You have to invest 20 lakhs, engage 20 lakhs rupees lawyer, you will get the order. Touts are everywhere. Who are the touts? That's the whole difficulty. Identification of tout is necessary. It is very easy to identify a poor man. He is a tout. A lawyer is a tout. Talking about is a tout. But identify. Take this system, bring this system, introduce a system to identify real tout in the judiciary, in the judicial system itself. It's correct what has been said. It's correct. It's an everyday's experience. Our judiciary has become, this is today, India, it has become too much expensive. Too much expensive. Unless you engage a very big face in the Supreme Court, you can't have an order.
Good money, good law, good justice.
Good money, good law, good justice. This is the practical thing in the country. That's going on. What is going on? You identify, sir, I will request you. You have come, you think real tout is bad. Real tout is, sir, no one there are one grade of lawyers are there amongst them who are who possess themselves that I am the bridge. I can bring the judgment. I can bring the order from the highest court. I can bring the order from that judge. I can bring the order from that judge. Come here. I will engage him. I will engage him. Don't worry. Sitting in 5-star, everything is settled and everything is getting. He is the main tout. What is the procedure? How you are identifying it? Since you have brought the bill, I have got the chance to speak. And I am speaking. I was thinking for decades together what is going on. I am a man of practical field. I am looking into these things. And this types of touts I will not tell all the judges, but of course, there are very few judges are there in our country, having a very good relationship with them. In their dinner party, they will go. In their lunch party, they will go. Their marriage anniversary, they will go. They will go. We know everything. Everything is known. Someone speak for 2 minutes, not 5 minutes face. Face law is very important in our country today to have an order, to get the justice. And who is getting that? The rich people are getting, not the poor people. Do you understand? Can you think about this country today, this judiciary is? Why the lakhs and lakhs poor people are not getting justice? Pending before the Supreme Court? Decades after decades. But Supreme Court is very much concerned whether there would be a marriage of the same sex or not. Therefore, Constitution bench will sit and they will go on hearing days in, days out, days in, days out. Peculiar things, sir. Sophisticated people, rich people, their problems would be entertained by the Supreme Court. Peculiar thing. I tell you, sir, do you know, this same-sex marriage, whether it to be done or not, within 3 days, bench has been constituted, matter has been heard, everything has been done. Do you know, for long 27 years, 7 judges bench of the Supreme Court is not hearing one matter which really pertains to the poor agriculture worker of the West Bengal. Can you imagine? For whom we exist? Do we exist for the purpose of, whether the judiciary exists for the purpose of resolving the problem of the most sophisticated or a very sophisticated things or the rich people? Sir, I tell you one incident. I am taking your time. I am sorry. Chief Justice Datu was sitting, I was sitting on that day. I will not take the name of a very senior lawyer, very famous lawyer. He went and he wanted to mention a matter of one industrialist. I must say, Chief Justice of India, Datu said, Mr. So-and-so, I have a number of matters of poor workers and poor peoples of this country. I don't have time, simply because you are appearing for the top industrialist, leaving aside everything, I have to take up your matter. I have heard it. But today's approach is different, peculiar. I am not taking any name. Big corporates, go, big lawyers, give big lawyers, go, mention, his matter will be taken up. What is happening in our country? Poor people are ignored. This is the place, that's the, sir, I must say, this is going on. Sir, point is, identified tout and non-identified tout. You are here, mayor making, you are trying to identify the tout. But the big arena, big places are there, big field, and non-identified tout is there. Nobody will tell them. Because they are not taking tea in the street shop. They are taking tea in the 5-star hotel. They will not be identified. Sir, identification, how can you remove? Highly paid lawyer comes out. They accept it. Don't worry. 50 lakhs. Don't worry. Get the order. Order is coming, engaging someone. He is not there, engaging someone. And that's because of face law. Come. This is happening. Tout is there. Tout is also there today. This problem is. I am coming to a very relevant question now. Tout is there when relatives of any judge is in the field of practice, legal practice. Tout is there. Taking the name of the judge, relative is also holding out threats. It has come into the newspaper. I do not want to take name. It is coming in the newspaper. It is under investigation. Let it be investigated. So since I have got the chance, I just tell you. Sorry, I just want to tell you one thing. I don't have, the Honorable Law Minister, I don't have any difficulties regarding any transfer. I don't have. I want it. I wish it. I want that there should be a policy. Unless a policy is there, transparency would not be there. Whatever is the policy, you transfer anybody. I am not concerned. Give a policy. At least 140 crore peoples of this country will understand this is a policy. On that basis, transfer would be made. But today, what is happening? Picking up, transfer. Picking up, transfer. If relative is practicing, for that reason, transfer all the judges who relatives are practicing in any high court. Why you are bringing a judge into the Supreme Court, High Court to Supreme Court, knowing fully well that his relatives is practicing in the Supreme Court itself? Why? Why picking up the names? If I am unfit, if I am dishonest, if I am not fit for anything in any court, I am not fit, I am not for any other high courts also. Point is very simple. Then again tout comes. No. Tout will say, this is the problem that has to be addressed. Of course, I support, sir, your bill. But I am on a very larger issue to save the Indian judiciary for future generation. For future generation. I am almost at the fag end of my career, legal service. How much years? 8 or 10 years, how much? But save it for generation after generation. The pain which I have faced, the things I have seen, problem is this, I have told somewhere, the judges, why they are saved? Supreme Court judges, High Court judges, I can criticize, only here I can criticize because of the privilege of the Constitution, because of the existence of the Contempt of Courts Act. Because they can't criticize, no one can criticize any judge's activities, judge's thing. Otherwise he will be hauled up for contempt. Our judges of the country are saved only because of the contempt of court. Don't think everyone is perfect, everyone is correct. There are so many persons. I take it, I used to take it earlier, it may be some aversions. Sorry, today I don't take it. It's an aversions. It has become a great disease of the Indian judiciary. That disease has to be resolved. I know. You are having a limited power. Limitation, I know. But this is the field, this is the place where I can tell my words. Let the highest court of this country take note of the contents which I have said. Thank you, sir.
श्री एन रेड्डप्पा जी, आप नाम भेजिए प्लीज, अपना नाम भेजिए. श्री एन रेड्डप्पा जी, प्लीज सेंड योर नेम, देन आई विल गिव यू अ चांस एंड देन यू विल स्पीक.
Thank you, Speaker Sir, for giving me the opportunity to participate in this discussion to introduce the Advocates Amendment Bill 2023.
Please.
There is nothing to oppose the bill. I fully support it. This is a welcome step. Advocates, for the important part of judicial system, they are not only the officers of the court, but also from the important bridge between those who seek justice and those who are empowered under the law to give justice. These amendments of Advocates Act were long pending and bring about a critical reform in the justice delivery system of our country. The importance of these amendments cannot be understood, and while these amendments are important, questions can only be raised as to accept on the consultation behind empowering the state agencies to act against liars, and secondly, the enforcement of a mechanism that will be required implement of this law. This is because while we want to that so-called Munnabai liars punished procedure also be brought about the ensure that there is no unnecessary prescription of any genuine liar, and through these amendments the independent judiciary is not hindered with, sir. One of the most crucial important of the justice delivery system in India is its human resource element, which is the advocate. The role cannot be overstated in the whole process. The act as bridge between the aggrieved and the adjudication institution. They also play an important role in shaping our society and not forget their role against courts to arrive at several judgments protecting the environment, sir. In 2017, two years ago, verification of drive by Bar Council of India found that only 50 to 60% practicing lawyers in India were genuine. this number was heavily reported in media. There needs to be a single public register for advocates across the country, which can be accessible by the public to across verify the claims of education qualification for each advocate they wish to engage with, sir. Advocacy may look like a very glamorous profession, but for those who are in public practice of law, it is for them the truth, sir. The Advocates Act needs to be further amended to ensure that certain benefits of social security are also extended to the junior advocates, and to ensure that advocates of the profession can retain the best talent in that there is no profession regarding this. I would like to suggest the Honorable Law Minister to take steps ensure that first generation of advocates are also be benefit from the targeted government schemes for health and housing and other methods of to them to be able to earn respectively for their livelihood, sir. Despite of the important attached profession, these are not concentrate measures to place to ensure their social security, sir. Even new lawyer in New Delhi has to pay around 15,000 rupees for enrollment fee at Delhi Bar Council, charging fees beyond that what is prescribed under Section 24, Subclass 1, Subclass F of the Section Advocates Act 1961, violate the right to equality under Article 14 and denies opportunities the uprising advocates, sir. I am requesting the Honorable Law Minister regarding enrollment fee of advocates. They are not in a position to pay advocates fee also, sir. In this regard, central government has to take some steps to provide minimum financial assistance to the rural advocates, particularly to construct their houses, to have bank loans and to pay enrollment fees and etc. Sir. Regarding in Andhra Pradesh government, our Honorable Chief Minister Y.S. Jagan Mohan Reddy is giving 5,000 rupees each junior advocates, all the advocates in Andhra Pradesh in every month, sir. There we have to appreciate the Andhra Pradesh government also, sir. Apart from this, I am requesting the Honorable Union Minister to strengthen this Amendment Act and also to implement the ideas of Dr. B.R. Ambedkar, which are in the Constitution. Union government has to take steps to introduce All India Judicial Service to implement, particularly to appoint judges in all the courts, including Supreme Court, to at least when All India judicial system is there, they are going to impart like IAS, IPS people, they are going to render some service to the rural level people. Otherwise, people from expected clients, they are not able to get justice from these courts. Therefore, I am requesting the Honorable Union Minister kindly introduce All India Judicial Service in the country. Apart from this, regarding touts also, touts anywhere, in a court, on all the department touts are there. It is not possible to curb them. It is not possible to us to take any action against them through law also. In this regard, the Union government has to take steps how to curb the touts system in all the systems, in all the governments in India level. Therefore, thank you very much for giving me the opportunity, sir.
Shri Bhartaraji Mehtab ji.
Thank you, Chairman, sir. At the outset, I should make it very clear. The bill is relating to advocates. Bill is not relating to courts or high courts or Supreme Court functions. Our attempt while deliberating on this amendment bill is to strengthen the advocates of our country and the system of jurisprudence in our country. This Advocate Amendment Bill clearly mentions two things. One is to repeal all obsolete laws of pre-independence acts, not totally, but which have lost their utility. This should be borne in mind. All the law is not being abolished. Those laws which have lost its utility are being removed. And Government of India is doing this in consultation with Bar Council of India. So these two things have to be borne in mind when we are deliberating on this subject. We know the history of Indian High Courts, how it was formed by an enactment of British Parliament in 1861, and subsequently what development has taken place in between. While going through the bill, sir, the definition of tout is also given. A tout means a person who procures in consideration of any remuneration moving from any legal practitioner. The employment of the legal practitioner in any legal business. This is the first part of the definition who the tout is. But subsequently, in the second subpara it is mentioned, the purpose of such procurement frequents the presence of civil or criminal courts or of revenue offices or railway stations, landing stages, lodging places or other places of public resort. So in that respect, it has been very clearly mentioned in the bill that those touts who operate for lower courts, they need to be apprehended, they need to be named, they need their names to be published, and they can be prosecuted. The impression of the government is, or the earlier law was, that touts do not exist in high courts. They don't exist in Supreme Courts. We should not presume that touts do exist. But my only humble suggestion is that a beginning is being made. It was there in earlier enactment, which is now getting incorporated in this amendment, in the Advocates Amendment Law, through this bill. And the best part is, the previous law which was there, now one cohesive law is coming into existence. This was introduced in Rajya Sabha last August. It was passed in also Rajya Sabha last August. It amends the Advocates Act 1961. This bill repeals certain sections related to touts under the Legal Practitioner Act of 1879. The bill provides that every High Court, District Court, Session Judge, District Magistrate and Revenue Officer not below the rank of District Collector can frame and publish list of touts. This bill makes the act of tout punishable. Means cases can be filed against them, they can be apprehended. But there are two aspects on which I would like to deliberate. One is the practitioner or the legal practitioners, the advocates, what need to be done for them. And the second is about 45, Rule 45 also is mentioned, that is relating to regulating legal education. That also needs to be looked into, which has not been addressed in this bill. There is Rule 36, which imposes 3 primary restrictions on lawyers. Firstly, lawyers are not allowed to promote themselves directly or indirectly. Second is, if a lawyer is involved in a case, they cannot advertise themselves in the media, newspapers, display their photo, or make inspirational comments. The question is, who is going to question the lawyers? Who is going to lodge a complaint against this type of dereliction of duty? Our expectation is the Bar Council of India will take cognizance of it and will deliberate on it, will take action on it. But are they doing that? during last 20-30 years since the inception of Bar Council of India? How many such cases has been deliberated by the Bar Council? Not a single complaint has been lodged, or has it been lodged and it has been glossed over? In consultation with the Bar Council of India, government is repealing the Legal Practitioners Act of 1879. Now the legal profession will be regulated by a single act. It is their responsibility to have quality lawyers. Section 36 of the 1879 Act is incorporated in the Advocates Act 1961. Some suggestions I have to make here for consideration of the government. Reform is a continuous process, and it has to be done with tune of time. There should be provisions for professional development of the lawyers in the Advocates Act 1961. There is no such provision even today, that how professionally an advocate can enrich himself. Technology has become all pervasive now. There are many emerging frontiers of law. Law to regulate telecom sector, law on intellectual property rights, Arbitration Act are some of those. Now, online dispute resolution has become a practice. Lawyers need to update with the latest development in the field of technology. Shouldn't we bring in these aspects in our amendment? How to legalize, how to make them more professional? That aspect we are missing. There should be, I would suggest, there should be, government may consider, there should be a national electronic register for advocates. Anyone, anywhere in the country can sit down and find out who are the advocates. Why should they take the help of touts? Or why should we presume that without a middleman we cannot approach a lawyer? We do not have any such register. The Law Commission in its 184th report had suggested as such. There should be a single database. This would be good to bring social welfare schemes for the lawyers also, because you have a single database of the whole country. There should be a digital interface between the advocates and the clients. This will eliminate the need for Section 45A in itself. Why do we need middlemen when we can have an electronic platform that can connect advocates and clients? I have a query also. Do we need intermediary that is being incorporated as Section 55 in the Advocates Act after repealing Section 56? When we have digital interface, is this provision necessary? Finally, I would vouch for an Advocates Protection Act. Since states have enacted such law, Minister for Environment and Forest is also present here in this house. Rajasthan has enacted that law. The present law minister is also from Rajasthan. Rajasthan has enacted a state law. I'm not aware how that law is functioning and how much protection this advocate protection law has given. But it. But I think it is necessary, because at times we also come across number of news where lawyers are attacked or lawyers are threatened or intimidated. Advocates need to practice fearlessly. The advocates, after all, are officers of the court. They are important stakeholders in the administration of justice. I believe the suggestions given shall get utmost attention of the government. The other part which I would like to mention is relating to the academic, regulating the legal education that needs to be strengthened. Large number of law colleges are being opened. But what is the quality of the lawyers? We all know. When the quality of the lawyers that are coming out from the law colleges, it is not only affecting the bar, it is also affecting the bench. So keeping that in mind, I think it is of greater need to look into these aspects also and to bring a comprehensive law in favor of the advocate and our advocacy system. Thank you, sir.
Supriya Sule ji.
On behalf of the Nationalist Congress Party, I speak on today's bill of the Advocates Amendment Bill. Sir, Meghwal ji has been a colleague to all of us and a pleasurable colleague for a long time. And he was the colleague who brought in the Women's Reservation Bill. And he's really lucky that he has brought in a bill, though it's not implemented. But he's lucky that in his legacy that he will leave behind, he'll be one of the finest ministers who has brought something which was very close to our hearts. And I'm not taking away his intent of this bill which he has brought in. I have only a few suggestions. I'm not a lawyer. Most lawyers have spoken before me. But the intent of the government, I'm sure, is very clear about what they want to do. But I have a few suggestions and questions to ask them regarding the implementation of this bill, which is actually really small. But there are a few questions I'd like to ask the Honorable out of my lack of legal knowledge. Is this that he says, what is a tout? Now, Mehtab ji has spoken about it, and so has Sri Raja from the DMK. But I seek a clarification from the Honorable Minister that he says that, which already Mehtab ji has read, that who procures in consideration of any remuneration. So it's a one-sided thing, any remuneration. So it's a one-sided thing. See, in the Corruption Act, both parties are considered to be making a mistake. Here, you are only considering one party to it. So should we not make it broader? And whoever engages or whoever hires, both ways, I think the practice is wrong, right? So why should only half the person be punished? So if you are really trying to remove touting completely, why not include both the parties? Is my question. So if he could kindly clarify on that. The other question for me is that who are the members present at every meeting? There is no clarity of it. In 45A, they've written that the explanation is the majority of members present at the meeting. Now, who will be the members? Who will decide what will happen at the meeting? Who will decide just with such a small thing who is a tout and who will be taking the decision? There is no clarity about this. Now, this is like Rajaji said, I'm reiterating the point, but there are no objects in the bill. It's probably little, I mean, it's a lawyer's bill which has such poor drafting, unfortunately, because there is, bill has to have its objectives. So there is no objectives in this bill. So what is the real reason of getting this bill? I'm again not taking away from the intention of the government. I'm sure the intention is, but when you are doing something for lawyers, isn't drafting and implementation most important than not just intent? Life is beyond intent. The other thing is about reforms which Meghwal ji said. Sir, I have never dealt with lawyers in my whole life, but in last 6 months I'm flooded with lawyers in my life, be it Election Commission or Supreme Court. And there is a saying in Marathi, sir, if with your permission, I would like to say it, that in Marathi they say, जो होशियार होता है ना, वो कभी कोर्ट की सीढ़ी नहीं चढ़ता है. जो होशियार है, तो कभी कोर्टाची पैड़ी चढ़त नहीं. अभी मैं होशियार नहीं हूँ, अभी मानना पड़ेगा, मैं तो चढ़ चुकी अभी. There was no option. So I had no option but to climb it. And clearly when you go to court, there are a lot of issues that are raised. The tout issue is discussed. But my whole point is there are a lot of reforms required in the court. I mean, justice delayed is justice denied. I don't want to go there. I know that's not the purview of the bill. But even one major point is injustice anywhere is a threat to justice everywhere is what Martin Luther King has said. So I think this is a very broader role that we need. We really need to expand this bill, the course of this bill, which whenever we meet young lawyers anywhere we get, you go to states, like somebody from YSR Congress, Jagan Mohan Reddy ji's party said that they are giving 5,000 rupees a month to young lawyers. In Kerala, they give, I think, 2,000. So is there something to engage all these youngsters who are studying very hard to pass it? So is there some social program this government has in mind, like most states are doing? That is my first question to this government. To reiterate, which technology upgrade? I think with technology, so many things are happening now. So is the entire game for lawyers going to change in the next few years? So how do they skill themselves to better? I mean, this whole thing about colonialization has been discussed. So it's a past, it's okay, good or bad. I think it's not been that bad on it. So let's not just criticize our history. The way forward is change, and change is inevitable in everybody's lives. And that's what policy is also. Policies also have to change with time. Look at the life today. Something like artificial intelligence, something we didn't even expect. A mobile phone we didn't expect about 10 years ago in our lives, which has actually changed our lives. So every profession is changing. So are the lawyers. So is there something this government has in mind for technology upgrade of all the lawyers? The Protection Act, which Mehtabji talked about, I'd like to take it a little forward, that many governments all over the country, not just talking about advocates, but they are even talking about doctors and press safety and security, because somehow I do realize, and we must all put our minds together in this government and in parliament, that there is somehow so much anger in society nowadays. I don't know where this anger is coming from, sir. Even in Maharashtra, we are having a lot of challenge. I'm not trying to digress, but I'm just giving you a small example. Please don't misunderstand what I'm saying. There are a lot of agitations going on in Maharashtra today on reservations, sir, be it Maratha, Dangar, Lingayat, Muslim Arakshans. A lot of stone pelting is suddenly happening. So there is clearly some anger breeding somewhere. You hear doctors getting beaten up. You hear threats like Mehtabji said about lawyers. There are press people who are getting beaten up. So there is something missing somewhere, sir. I think this entire House Parliament with legislation, we even need to discuss all these social issues, because the intent of changing people's lives for the better is what. That's why we get elected and come here. So at policy level, the intent of the government to bring in to removing of the touts is a very welcome step. Sir, the only thing when I was hearing about touting was, आपको भी याद होगा हम लोग सब थे, तभी तो मल्टीप्लेक्सेस थे नहीं, तो वो टाउट्स खड़े रह के वो टिकट सिनेमा की बिकते थे, 10 रुपया का 100 रुपये में टिकट, अभी वो आईपैड वगैरह नहीं था. That whole touting business is over, because first day first show, life out of us is over. So technology does evolve life, so it will probably eventually do remove touts. But till then, can we do something better, which is simpler, positive, and like Meghwal ji said, Raja ji said, I would like to reiterate their points that why not bring a compressive bill, bring it, we could put it into the law ministry. The law minister is very fine, he's very supportive to all the demands of women that he did for us in the women's reservation bill. So I'd request him to take this back. Let's all take all the points suggested by all the renowned lawyers in this house, bring a more comprehensive bill, take all the feedback, maybe send it to a standing committee. There are good lawyers, even in the, I think the environmental minister is also a lawyer, if I stand corrected. Maybe some feedback from him also as a lawyer, and have a more comprehensive bill in the larger interest of the advocates of this country. Thank you, sir.
Shri K. Sureshi.
Sir, give me opportunity to participate in this bill. Sir, let me begin by quoting Mahatma Gandhi ji, who himself was a lawyer and an ardent champion of justice. An unjust law is itself a species of violence. Arrest for its breach is more, so states Gandhiji. The quote means that any law must be aimed at delivering justice and vacating grievances of the oppressed, and if a law is unjust, arresting someone on the basis of the law is a form of violence. So the law has to be just to itself first. It is the context of the bill and my speech. The bill titled Advocate Amendment Bill 2023 is aiming at the insertion of new section, which is section 45A in the 5 of the Advocate Act 1961, which grants power to frame and publish list of touts to every High Court, district judge, session judge, district magistrate, and every revenue officer not being below the rank of collector of a district, each as regards their own there are his own code and the codes if any subordinate there. I have certain observation and recommendation in this regard which are follows. As per the law, the authorities empowered to frame and publish a list of doubts as provided under section 45A should be confined to only judicial authorities and not executive magistrates. If the district magistrates are given such power to frame rules, we cannot ensure transparency in finding out actual doubts as defined under section 45(7)(b) of the amendment bill. Sir, similarly, the offence under the amendment bill as provided under section 45(6) may be cognizable offence and the penalty be enhanced to minimum 1 year and fine at least 10,000 or else no purpose would be served. Apart from these suggestions, I would like to ask the government, through you, sir, that who is the tout and what are the benchmarks that you will use to identify a person as a tout. It is absolutely agreed that touts are a menace to the courts and justice system. What about people who would be implicated as touts when an excessive power is given to the courts? Any innocent person could be branded as tout, and that will be a dangerous situation. Sir, the question here is, we live in a highly polarized nation, divided by hatred and intolerance and discrimination. In this scenario, if excessive powers are given to the officers of the court to determine touts, anyone could be expelled from coming to the court premises. For example, a Dalit could be branded as a tout just because he is a Dalit, and an officer belonging to the upper caste and harbors discriminatory behavior towards Dalits or other communities. Another aspect is the amendment bill does not take into account any standard procedures for fixing the modes of appeal for a person branded as a tout other than appeal. This mechanism is problematic at many levels as the appeal system in many occasions is found to be biased, and therefore I demand that appeal committee must be consistent representative of SC/ST community so that communal representation is ensured. I hope the Honourable Minister will agree my suggestion. Apart from this, I would also to be add that there are many issues concerning the legal system, including the reservation for scheduled caste, scheduled tribe in appointment of judges, the higher courts, which has been long-standing demand for many decades. I would like to appreciate Honourable Minister Sri Arjun Megwal ji, who is coming to this ministry. So he also always for fighting the cause of untouchable people. In the law ministry, in your period, you have to take so many mechanisms for the representation of SC/ST in the Indian judiciary. I also demanded that young advocates of SC/ST community must be given necessary stipends and financial support systems during their practice, and juniors, as they are finding it difficult to survive in the present condition. The demand for high court, the demand for another important demand I would like to bring your notice, our long pending demand for the high court benches. So in various states there is a demand for high court benches. In Kerala also long pending demand to set up a high court bench in Trivandrum. So I would like to request Honourable Ministers to consider our long pending demand. Sir, furthermore, I would like to conclude saying that the amendment aiming to identify and expose doubts must not become a tool for opposition of any individual and justice in the fairness must be implemented. With these words, once again, I congratulate Honorable Minister Sri Arjun Megawal ji as a law minister in this country to bring this important decision. Thank you very much.
Thank you. Shri P.P. Chaudhary ji.
धन्यवाद सभापति महोदय, आपने मुझे इस महत्वपूर्ण बिल पे बोलने का मौका दिया। मैं इस बिल का सपोर्ट करता हूं और मैं चाहता हूं कि माननीय सभी सदस्य इसको सर्वसम्मति से पास करें। मैं धन्यवाद देता हूं माननीय मेघवाल साहब को कि इस बिल को आप लेकर आए और इसमें 2 एस्पेक्ट जो सभापति महोदय बहुत इंपॉर्टेंट, प्रैक्टिशनर एक्ट जो है वो 1870 उसके सारे ऑलमोस्ट प्रोविजन जो हैं वो एडवोकेट एक्ट में ले लिए गए हैं और एडवोकेट एक्ट के द्वारा ही गवर्न होते हैं। सिर्फ एक प्रोविजन जो रहा है वो टाउट का रहा है। उस प्रोविजन को जो उसका सेक्शन 36 है वो सिर्फ टाउट के लिए हमें लीगल प्रैक्टिशनर एक्ट 1879 को देखना पड़ता है और वो प्री ब्रिटिश टाइम का बना हुआ है, कॉलोनियल टाइम का बना हुआ है। और हम टाउट की डेफिनेशन को और टाउट के उसके प्रोविजन को देखने के लिए लीगल प्रैक्टिशनर एक्ट 1879 देखते हैं। और जबकि सारा का सारा एडवोकेट एक्ट में दूसरी चीजें जो लीगल प्रोफेशन को रेगुलेट करने की बातें हैं वो आ चुकी हैं, तो इसलिए वो पूरा का पूरा डेफिनेशन जो है और उसके प्रोविजन सेक्शन 45A एडवोकेट एक्ट में इनकॉर्पोरेट करके ये बहुत अच्छा किया। इसलिए माननीय मंत्री जी को, मेघवाल साहब को मैं धन्यवाद देता हूं। और आप, क्योंकि जब भी वो प्रोविजन जब इसमें इनकॉर्पोरेट हो जाएगा और ये लागू हो जाएगा, उसी समय जो एक कॉलोनियल एरा का जो लॉ है, जो लीगल प्रैक्टिशनर एक्ट 1879 है, वो लॉ खत्म हो जाएगा, वो रिपील हो जाएगा। इसका भी प्रोविजन इसके साथ में दिया है। और दूसरा एस्पेक्ट जो है इसका टाउट का है। आप देखिए लीगल प्रोफेशन में ये बहुत बड़ा स्टिग्मा है। हम दूसरे जो बिजनेसेस हैं उसमें ये दलाल हो सकते हैं, लेकिन लीगल प्रोफेशन जहां है उसमें दलाल का कोई परिभाषा, कोई जगह नहीं है। इसलिए एडवोकेट एक्ट में भी ये प्रावधान क्या है, चाहे हमारे बार काउंसिल ऑफ इंडिया हो, चाहे रेस्पेक्टिव बार काउंसिल, स्टेट बार काउंसिल हो, चाहे एसोसिएशन हो एडवोकेट्स की, लीगल प्रैक्टिशनर की एसोसिएशन हो, सब ये मानते हैं लीगल फ्रेटर्निटी के लोग कि इस तरह के जो टाउटिज्म जो है इस प्रोफेशन में नहीं होना चाहिए। ये बहुत ही एक अलग तरह का प्रोफेशन है। तो इससे सबसे ज्यादा जो तकलीफ में आते हैं वो आते हैं सबसे ज्यादा समाज के अंतिम छोर पे जो व्यक्ति हैं, जो इनोसेंट हैं, जो जानते नहीं हैं। चाहे किसान ले लो, चाहे शेड्यूल कास्ट ले लो, शेड्यूल ट्राइब्स ले लो, और चाहे हमारे मातृशक्ति ले लो, जो गरीब हैं, उन लोगों को जब कोर्ट में उनको ये पता नहीं होता है तो वो ऐसे लोगों के टाउट के चक्कर में आते हैं और उनके पैसे भी ज्यादा खर्च होते हैं। आप एक तरफ देखेंगे, चाहे कॉरपोरेट हो, चाहे बड़े बड़े बिजनेस हो, चाहे बड़े लोग पढ़े लिखे लोग हों, या वो लोग जो हैं वो आइडेंटिफाई कर लेते हैं कि कौन से लॉयर को करना, कौन से लॉयर को नहीं करना, तो उनको वो परेशानी नहीं आती है। लेकिन इसमें जो सबसे बड़ी जो अगर टाउट है तो सबसे बड़ी परेशानी आती है वो गरीबों को आती है। तो ये बहुत बड़ा कदम मोदी सरकार के द्वारा लिया गया और मैं धन्यवाद देता हूं पुणे मेघवाल जी को कि आपने इस तरह की डेफिनेशन जो एडवोकेट एक्ट 1961 में ला करके, जो कि इंडिपेंडेंस के बाद में ये एक्ट पास हुआ और कॉलोनियल टाइप के कानून को खत्म करके पूरा का पूरा रिपील करके इसमें लाएं, जिससे कि कम से कम ईज ऑफ डूइंग बिजनेस और ईज ऑफ लिविंग का जो है प्रधानमंत्री जी का जो विजन है वो विजन भी फुलफिल होता है। और सबसे बड़ी बात है कि गरीबों के साथ जो अन्याय हो रहा था लगातार, क्योंकि लीगल प्रोफेशन में सबसे बड़ी तकलीफ है। आप देखेंगे कि कहीं से भी गांव से सबसे ज्यादा विक्टिम जो होता है वो गांव का व्यक्ति होता है, इनोसेंट होता है, कमजोर होता है, गरीब होता है। वो जब अगर शहर में आता है या कई शहर से अपने किसी वकील को करता है तो उसको मिसगाइड किया जाता है। तो इस मिसगाइड को रोकने के लिए बेसिकली इसका अगर मेन स्पिरिट और ऑब्जेक्ट है तो उसको ऐसे लोग उसको मिसगाइड नहीं कर रहे हैं जिससे कि एक ऐसे वकील के पास ले जाएं जो कि वो लीगल प्रैक्टिशनर इतना साउंड नहीं हो, लेकिन उसके पैसे जो वकील ले जाएगा और वकील के दोनों के पैसे उनके बढ़ते हैं और उसके जो भार जो पड़ता है उस गरीब पे पड़ता है। तो ये कानून जो लेके आया है उन गरीबों को राहत देने के लिए लेके आए हैं। और इस तरह से वो जब अब इसमें हम देखें 3 व्यक्ति इन्वॉल्व हैं। एक आप देखेंगे लिटिगेंट, जो लिटिगेंट इसमें सबसे ज्यादा वो होता है जो इनोसेंट है और पुअर है, और दूसरा होता है वो पर्सन एनी पर्सन एडवोकेट भी हो सकता है और अदर देन एडवोकेट भी हो सकता है। वो जो है दूसरे जिसको एडवोकेट एंगेज करते हैं उसके एवज में उसके लिए वो अपनी दलाली लेता है और वो दलाली का भार जो है उस पे गरीब पे पड़ता है। लेकिन भार भी नहीं पड़ता है, उसके साथ साथ दूसरा जो है उसको क्वालिटी लॉयर भी नहीं मिलता है, उसकी वजह से उसको नुकसान भी होता है। जब उसको सर्विसेज प्रॉपर जो मिलनी चाहिए लीगल प्रोफेशन में वो सर्विसेज नहीं मिलने की वजह से उसको नुकसान होता है। और इस वजह से ऐसे लोगों को आइडेंटिफाई करना बहुत जरूरी है। अब जहां तक आइडेंटिफाई की बात है, अब आप देखेंगे कि जो एक इनोसेंट है, एक पुअर पर्सन है, वो अपना वो एडवोकेट करता है उस दलाल के माध्यम से, उसको ये पता नहीं होता है कि ये दलाल है या मेरी मदद कर रहा है, और वो उसको जाकर करके उसके एवज में उसको पैसे देता है और रिटर्न देता है, उसको कंसिडरेशन देता है उस दलाल को। तो एक तो ये पता होना चाहिए कि आइडेंटिफाई करने के लिए, और इसमें कंप्लेनेंट जो है बेसिकली जिसने कंसिडरेशन दिया और जिसने लिया वो तो एग्रीड हो नहीं सकती। सिर्फ और सिर्फ एग्रीड जो होता है वो इनोसेंट होता है और उसको ये नॉलेज नहीं है कि इसके खिलाफ कंप्लेंट भी हो सकती है। उसको ये पता नहीं है कि ऐसे लोगों को जो उनकी लिस्ट भी पब्लिश होगी या उनके खिलाफ कार्रवाई भी हो सकती है। तो इस तरह से इस तरह के लोग जो हैं, जैसे मेरे पूर्व ऑनरेबल मेंबर ऑफ पार्लियामेंट ने ये भी बताया कि यहाँ पर हाई कोर्ट और सबऑर्डिनेट कोर्ट्स में लिया है, लेकिन सुप्रीम कोर्ट में भी होता है। अगर ऐसे ये लोग सुप्रीम कोर्ट में भी हो सकते हैं, घूमते सारी जगह घूमते हैं। तो कोई भी प्रशिंक्ट हो, चाहे सुप्रीम कोर्ट हो, चाहे हाई कोर्ट्स हो, चाहे सेशन कोर्ट हो, चाहे डिस्ट्रिक्ट कोर्ट हो, चाहे रेवेन्यू कोर्ट्स हो और चाहे ट्रिब्यूनल हो। इसमें हालांकि ट्रिब्यूनल की कहीं यूज नहीं किया है उसमें वर्ड, लेकिन मेरा मानना है कि किसी तरह की कोर्ट हो और उसके साथ कोर्ट भी नहीं, उसके अलावा ये लोग रेलवे स्टेशन पे मिलेंगे, ये लोग बस स्टैंड पे भी होंगे, ये पब्लिक जहाँ प्लेसेज हैं वहां पर भी उन लोगों को देखते हैं। तो ये लोग जो हैं अवेलेबल, जो कोर्ट का एक हमारी जो एक फेयर इमेज है न्यायालय की, उसमें जो है इसका इन लोगों का आइडेंटिफाई करने के लिए ये कानून लेकर आए, इसलिए इस बात के लिए भी इनको बहुत बहुत धन्यवाद। लेकिन जो लिस्ट बनती है उस लिस्ट में सबसे बड़ी बात है कि उसके लिए एविडेंस गैदर करना ये बहुत बड़ा हरकुलियन टास्क है। तो मैं माननीय मंत्री जी से निवेदन करूंगा, जो इस एक्ट के तहत में रूल बने उस रूल में एम्पल प्रोविजन ऐसे हों जिसमें इन लोगों को आइडेंटिफाई कैसे किया जाए, क्योंकि एविडेंस जो है जब तक वो इनोसेंट व्यक्ति वो एग्रीड, सिर्फ और सिर्फ इसमें एग्रीड वही होगा, क्योंकि ना तो दलाल एग्रीड होगा और ना ही वो एडवोकेट जिसको ये उससे कंसिडरेशन लिया जाएगा वो एग्रीड है। तो उसमें उसको बचाने के लिए उस इनोसेंट की हेल्प हम कैसे कर सकते हैं, वो हम इसको एक्ट को प्रॉपर इंप्लीमेंट करने के लिए उसमें रूल किस तरह के फ्रेम करें। तो इस तरह से रूल का इंटेंट एंड ऑब्जेक्ट ये होना चाहिए कि उस इनोसेंट व्यक्ति को हम किस तरह से हेल्प कर सकें, जिस तरह से ऐसे लोगों को आइडेंटिफाई करके उन लोगों की लिस्ट जो है वह पब्लिश हो। अब लिस्ट पब्लिश होने के बाद में कॉन्सिक्वेंशियल इफेक्ट क्या है? कॉन्सिक्वेंशियल इफेक्ट 2 है। एक इफेक्ट है उसको उस परिशिंग से, उस न्यायालय से वो उपस्थित नहीं रह सकता, उसके अंदर वो नहीं रहेगा तो बाहर ऑपरेट करेगा कहीं न कहीं। तो ये उसके साथ में दूसरा जो कॉन्सिक्वेंशियल इफेक्ट है उसको पनिशमेंट का है, उसके 500 रुपीज पेनल्टीज का है, और इम्प्रिजनमेंट जो है वो बहुत कम इम्प्रिजनमेंट है। उसमें जो है हम इस क्राइम को रोक नहीं सकते, और आज की तारीख में 500 उससे हम लेकर के उससे बहुत कम अमाउंट ये है। और दूसरा जो पनिशेबल इम्प्रिजमेंट विद में एक्सटेंड टू 3 months और विद फाइन और बोथ। तो अगर उसको कहीं किसी लेवल पे सिर्फ फाइन ही इम्पोज करें तो 500 रुपीज फाइन होंगे, लेकिन इनोसेंट व्यक्ति जो है उसके साथ चीटिंग होगी, उसका हो सकता है केस भी उसने खराब कर दे। तो इसीलिए ये सफिशिएंट प्रोविजन इसको प्रॉपर इंप्लीमेंट करने के लिए रूल्स में आ जाए, जिससे कि गरीबों को फायदा पहुंचे। तो ये प्रधानमंत्री मोदी जी के नेतृत्व में ये बहुत ही ऐसा कदम है, विजनरी कदम, जो बेसिकली जो हम ये कह सकते हैं कि जो न्याय मिलना है गरीबों को, उस न्याय मिलने में जो ये बाधा है सबसे बड़ी, उस बाधा को हटा करके और इनोसेंट लोग, गरीब हो चाहे शेड्यूल कास्ट हो चाहे कोई हो, इस तरह के लोग जो गांव के कहीं फार्मर हो, उन लोगों के साथ में धोखाधड़ी नहीं हो, ये कानून उस दशा में है। इसलिए मैं बहुत बहुत पुनः माननीय मंत्री जी अर्जुन राम जी मेघवाल साहब को बहुत बहुत धन्यवाद देता हूं कि प्रधानमंत्री मोदी जी के नेतृत्व में आप ये कानून लेकर आ रहे हैं। बहुत बहुत धन्यवाद।
ऑनरेबल मेंबर श्री मालिक नायर जी।
बोलने का मौका दिया और ये एडवोकेट अमेंडमेंट 1961 में जो टाउट्स की बात हो रही है, पहले टाउट्स का सोचना पड़ेगा कि उनको क्या शब्द दें। कानून के पालन कराने के लिए गैर कानूनी तरीके से अगर कोई धन कमाता है, उसे बिचौला कहें, दलाल कहें, क्या कहें, उसको रिमूव करने की बात, और जो लोग को ठगने से बचाने की बात जो अमेंडमेंट में आई है, इसका हम सपोर्ट करते हैं, स्वागत करते हैं और एक अच्छी पहल है। लेकिन इसमें वाकई में जो हमारे साथी बोल रहे थे, जो सफरर हैं, इनोसेंट लोग हैं, इसमें अगर उनको ज्यादा सख्ती की तो वो बिल्कुल महरूम रह जाएंगे, उनको तो कुछ पता ही नहीं चलेगा। तो मैं साथ के साथ माननीय मंत्री जी से कहना चाहता हूं कि एक ऐसी व्यवस्था करें जिससे जो गरीब लोग हैं, जो बहुत दबे कुचले लोग हैं, जो SC ST के लोग हैं, जो पिछड़े लोग हैं, उनको कोर्ट में एक ऐसी व्यवस्था करें, एक कमरा ऐसा बने जहां जाके वो कुछ जानकारी लेना चाहें, कुछ सुविधा लेना चाहें, तो उनमें कुछ बार काउंसिल्स को पावर दें, वहां के लोग हों, और अलग से राजनीतिक रूप से एक ऐसा कोई अलग से भी लोग डिप्यूट करें जो उसमें मौजूद रहें और जो उनको काउंसलिंग कर सकें और उनको सही रास्ता दिखा सकें, जिससे वो उनसे बचकर के उनका धन भी खर्च ना हो, उनके साथ ठगी भी ना हो और उनको न्याय मिलने की तरफ आगे बढ़ सकें। इससे संबंधित मैं एक बात और कहना चाहता हूं। जो बात कानून की हो रही है, वो पिछले दिनों महामारी हुई, कोरोना के समय में जो वकील थे वो दूसरा कोई प्रोफेशन कर नहीं सकते थे कि अगर कोई महामारी या ऐसा आ जाए तो उस समय सरकार ऐसी व्यवस्था करे कि वकीलों को भी दूसरा कोई काम करने का या कॉन्टीजेंसी फीस को अलाउ किया जाए ऐसे समय में। एक चीज और कहना चाह रहा हूं, हमारे लॉ एंड जस्टिस कमेटी में, DOPT लॉ एंड जस्टिस कमेटी में भूपेंद्र यादव जी रहे हैं, बहुत काम किया, मीटिंग, हमें भी बहुत कुछ सीखने का मौका मिला है वहां पे। तो उसमें भी मैं एक बात कहना चाहता हूं कि जो लीगल एजुकेशन है उसमें हमारा देश कहां खड़ा है, सरकार को ये इवैल्यूएट करें। हमारे देश का अगर पूरे वर्ल्ड वाइज रैंकिंग का हम पूरा रैंकिंग निकालें तो 551 नंबर पे IIM अहमदाबाद आता है केवल मात्र। बाकी जो उतनी भी बढ़िया यूनिवर्सिटीज हैं वो 25,000 के बाद सब आती हैं। तो जो वर्ल्ड के पैमाने पे ये UCL है, वहां से महात्मा गांधी और रविंद्रनाथ टैगोर पास आउट हैं, वो रैंकिंग 4 पे है। रैंकिंग 5 LSC जहां से बाबा अंबेडकर साहब पास आउट हैं। ऐसे ही आईवी लीग है, जो 7 यूनिवर्सिटी टॉप मिलकर के उन्होंने एक लीग बनाई कि हम एक लीग है, हम रैंकिंग 1 है। तो इसी तरह जो लीगल एजुकेशन है, जहां सरकार का और बार काउंसिल का मिल करके हस्तक्षेप है, तो सरकार इस तरफ भी ध्यान दे कि उस सिस्टम को कैसे इंप्रूव करें। जो हम देखते हैं हमारी स्टैंडिंग कमेटी में बार काउंसिल सरकार के ऊपर डालती है, सरकार के ऑफिसर बार काउंसिल के ऊपर डालते हैं, तो इसमें भी कोई ना कोई ऐसा प्रोविजन सरकार करे जिससे कि वहां इतनी पारदर्शिता हो जाए और हमारे देश का लीगल, वो मीडिएशन की बात हो चाहे वो आर्बिट्रेटर की बात हो, जितना देश हमारा आज तरक्की कर रहा है और वकीलों से संबंधित भी हमारा देश उतना ही तरक्की करे और पूरे वर्ल्ड में हमारे देश के आर्बिट्रेटर सिस्टम से और मीडिएशन सिस्टम से और हमारे देश की एडवोकेसी से पूरे वर्ल्ड में एक नाम हो कि भारत, जहां विदेश में लोग पहले पढ़ के आके नाम चीन हो काम के लिए आज है। बस अब खत्म कर रहा हूं, बस मैं एकदम खत्म कर रहा हूं। एक बात और कहना चाहता हूं मैं कि जो ये टाउट्स की बात हो रही है, ये मान लो जांच में आ गए और घेरे में आ गए और पकड़ लिए, उनको ऐसी सजा मिले जिससे ऑटोमेटिक आगे बंदिश लगे। और एक चीज और मैं मंत्री जी का संज्ञान दिलाना चाहता हूं कि जो लोग के पास कोई बस डिस्कस करने आ जाओ, उनको झूठी सच्ची बोला यूं कर दूंगा और झूठे सच्चे नोटिस, झूठे सच्चे केस, तो ऐसी भी एक व्यवस्था सरकार सोचे, मंत्री जी सोचे कि उसमें जांच हो कि इस वकील ने 100 केस पिछले कैसे करे हैं, उनमें सब पे क्या झूठे केस डले हैं, उनकी एक लिस्ट बने और वो लिस्ट वेबसाइट पे पड़ी हुई हो, जिस लिस्ट को देख करके किस वकील के पास जाना है, किस वकील के पास नहीं जाना है, इस पे पूरा लोग ध्यान दे सकें। और साहब बस खत्म कर रहा हूं, जो गांव देहात के लोग हैं, जहां इंटरनेट और जहां पे नेटवर्किंग नहीं है, वहां इंटरनेट और नेटवर्किंग के कनेक्शन, चाहे वो सरकारी विभाग हो टेलीफोन से संबंधित, चाहे प्राइवेट सेक्टर के हो, इस पे भी पूरा ध्यान दिया जाए। और साहब मैं एक जहां से मैं जीत के आता हूं, वहां राजेंद्र अग्रवाल जी हमारे बैठे हैं भी, और वो भी बैठे थे, जो बागपत के सत्यपाल जी भी बैठे हैं यहीं पे। जो पश्चिम उत्तर प्रदेश में हमारा जब चुनाव होता है तो 27 MP, 141 MLA, सबके सब MLA के कैंडिडेट और MP के कैंडिडेट ये कहते हैं कि हमें जिता दो और हम पश्चिम उत्तर प्रदेश में मांग करेंगे कि यहां पे हाई कोर्ट की स्थापना की जाए। तो आज आपके माध्यम से मैं सरकार से मांग करता हूं कि पश्चिम उत्तर प्रदेश, जिसमें मेरठ लोकसभा, बिजनौर लोकसभा, नगीना लोकसभा, सहारनपुर लोकसभा, केरल लोकसभा, अमरोहा लोकसभा, बागपत लोकसभा, गौतम बुद्ध नगर लोकसभा, बुलंदशहर लोकसभा, सबको फायदा मिल सके, तो सरकार इस तरफ ध्यान दे और जल्द से जल्द, ताकि पश्चिम उत्तर प्रदेश में खत्म करो। सब आखिरी लाइन है बस, पश्चिम उत्तर प्रदेश के लोग जो इलाहाबाद जाते हैं, कई सौ किलोमीटर, पूरी रात लगती है, पूरी दिन लगती है, सर सुविधाएं भी नहीं होती, ट्रेन में टिकटें नहीं मिलती, बहुत दिक्कत का सामना कर रहे हैं। पश्चिम उत्तर प्रदेश में मेरठ में हाई कोर्ट की बेंच की स्थापना की जाए। धन्यवाद सर।
ऑनरेबल मेंबर श्री हसन मुसदी।
Thank you, Honorable Chairperson, for allowing me to participate in the discussion on the Advocates Amendment Bill 2023. Sir, the problem is identified in the Act. It has plagued education system, for last more than 100 years. The first attempt was made in 1879 to provide some kind of response to the problem. Sir, while I stand in support of the bill, but all the same, I have reservations about the efficacy of the mechanism devised in the bill. Sir, I am skeptical about whether the results of the bill, whether it will achieve the intended purpose. Sir, our courts, subordinate courts, are burdened with 50 million pendency. 50 million cases are pending in our subordinate courts. And the authority identified here, who is to identify who is the tout? Who has to go for that kind of an exercise? Because it is not that somebody will call somebody a tout or somebody will identify somebody or publish a list. Then a procedure is to be followed. And who is burdened with that? Who is saddled with that responsibility to identify prepare the list and identify the person? It is High Court, District Judge, Session Judge, District Magistrate, and Revenue Officer. Sir, they are already overburdened. How come that a District Judge or a Session Judge can embark on that exercise and whatever is the cause list for the day, and also now deal with the other problem that, as I said, that afflicts the system. There is a malaise for the system. Sir, I think that this may not, that is why I am doubtful whether this system, the mechanism devised will be able to achieve the target. It is true that there is a large number of doubts, particularly in trial courts. But the process, the exercise to prepare the list and allow the person who is affected by the list or is affected by the exercise that may be undertaken by a district judge, he has to be given a right to respond to the allegations. So how can a district judge or a session or a subordinate judge deal with the exercise or prepare the list? I think that is doubtful whether this system will bear the results. The right thing would have been that we designate an authority in a district court, like we have in High Court. We have a registrar vigilance or a vigilance commissioner who deals with cases of misconduct against lawyers. The same way in every district court we have an authority to deal strictly with this problem and prepare the list and do whatever exercise is going to be done to go follow that exercise. So this is one reservation about it. Because what I have heard from other honorable members, there is some kind of a misconception about the problem. The target group that is sought to be addressed, the problem that is sought to be addressed. It is not that every tout. It is only the touters who operate from the court premises. Because our gullible people, the people who visit the courts, they are mostly affected by the people who operate from the court premises. That is why in para 5, clause 5, it says that the judge shall, one of the punishments will be that the judge will exclude him from the court premises. The person who finds his name in the list, the sessions judge or any other judge who is presiding over that court, he can exclude his presence from the premises of the court. That is, they shouldn't. So this is not targeted against all the touts, in whatever color and whatever costume they wear. It is only restricted to the touts who operate from the court premises, and one of the punishments to be proposed to be given is to exclude him from the premises. But while preparing this list, and fulfilling all the procedural requirements, the procedural due process, because a person cannot be declared as a tout unless and until he is given a reasonable opportunity. I don't think that the system devised under the Act is going to get the results that we targeted. Second is the target. One of the target group is not only the gullible litigant, the litigant who comes to the court, visits the court for redressal of some grievance. It is also the junior lawyer, because these touts mostly eat up the work that may be dealt with by the junior lawyers, the entrance to the profession. So this is one of the welcome steps. This will be just received with that kind of enthusiasm by the junior lawyers who enter the new freshers in the law courts. But at the same time, I would urge Honorable Minister to propose some kind of measure, some kind of amendment in the Advocates Act that provides for some honorarium or some kind of support to the fresh entrants, to the new entrants to profession, because those are tough years for a junior lawyer. The initial 5 years are very tough years for junior lawyer. I had proposed a private member's bill for assistance, giving assistance to advocates. I think that would be a welcome step if that is done, so that they get some kind of a relief. But with that, with whatever I said about the mechanism and my reservations about the mechanism, it's a welcome step, and there should be some kind of a second look on it, so that instead of burdening the sessions judge or the presiding officer of the court with this exercise, who's already overburdened, it will be better to have a designated officer, like a vigilance commissioner, as we have in courts, in high court, a vigilance commissioner or a registrar of vigilance, the officer who is asked to exclusively deal with the problem and go and complete the exercise, and then only he will be able to efficiently identify the objects of this act will be achieved. Thank you.
Thank you. Honourable Member Sri A.T. Mohammed Bashiri.
Sir, thank you very much. Sir, this piece of legislation is like a fait accompli one. Sir, in 1961 Advocate Act was based on certain authentic reports and recommendations of the judicial commissions, and 1879 Act was there, when 1961 Act covered all the issues raised in the other parent act, and that is perfect. Unfortunately, this particular thing that is pertaining to touts was missed in it. This is to fill up that. That is the scope of the act. That's okay. Now, sir, what I would like to point out is, I heard the former speaker's speech. Mainly, they are all not only MPs, they are eminent lawyers also, legal luminaries. They were all sharing certain apprehension. Number one is, how is the procedure in identifying and listing the touts? The procedure stipulated when this act is having confusion. So that is to be readdressed. So they were citing certain burning issues, such as deterioration in the judicial system of our country. Similarly, sir, there is a wide kind of criticism that impartiality and independence of Indian judiciary is diminishing like anything. That also is a point of concern. Sir, another point which you have raised also, sir, lack of representation for underprivileged sections, SC, ST and OBC. Sir, there is no judicious competition in the higher judiciary as far as these marginalized sections are concerned. Sir, we all know that trustworthiness of the judiciary should be adhered strictly. No doubt about that. All kind of unfair practices should be curbed. That also is truth. Transparency and ethical values should also be strictly adhered. We have to ensure there is no loopholes in the existing structure to lose the trustworthiness of judicial system in our country. Sir, we all know the relation of the responsibility of the lawyers. Section 1 of the Chapter 2 of the Part 4 of Bar Council of India frames code of conduct and etiquette of advocates and prescribed duties of advocates in the court. Sir, that is very clear. Code of conduct was laid up. That shows that lawyers should not take up any cases where client may have some wrong thinking, and there should be a clarity over that also. Similarly, sir, the unfair practices, wherever it is to be curbed and it is to be discouraged. So, then not only that, Code of Conduct says that lawyers should not promote any kind of unauthorized practice to make like advertisement and solicitation of work like that. So that kind of canvassing also should not be there. That also can be treated as a bad practice. Similarly, lawyers' responsibility has also been categorized in that. What is that? They have a responsibility to court, to do justice. In that way also, the relation with the judges, that also is a very important thing. In fact, sir, lawyers, it's not just a profession like that, sir. It's a noble profession. It's a very sacred profession. In that way, a lawyer is duty-bound to educate his client not to have any kind of unfair practices, sir. As far as judicial credibility, transparency, and accountability is concerned, the whole nation is worried about that, sir. Any kind of lapses taking place there is a trouble one, a very worrisome kind of thing. We have to address that also, sir. Similarly, sir, the relation with judges and the lawyer, that also is a very important thing, sir. Like that, you know that bar, that is advocates, and bench, that is judges, play an important role in administration of justice. The judges administer the law with the assistance of the lawyers. The lawyers are the officer of the court. It's a very important thing, sir. Unfortunately, there is some kind of misunderstanding developing with certain judges and the lawyers. That also is an unhealthy practice. Yes. That also may kindly be addressed. Sir, towards the end, I would like to say one thing for what is called a loud thinking. Now, sir, what is happening? There is a complicated situation. Judges, it's a very, very, very powerful position, and very important also as far as the constitution is concerned. But I would like to make just a submission, not a conclusion, for the loud thinking of this House. Reappointment of the judges.